So good morning, everyone. Good morning. Доброго ранку. I'm Slava Vlasov, tax and legal leader for PwC in Ukraine. I would like to welcome you to our webinar this morning. And we have 26 people online and much more are expected to join. Let's give it 1 minute and then we will start.
In the meantime, I will introduce myself. I'm Michał Grzybowski. I'm a partner in PwC Poland, and I have a privilege to co-host this webinar with Slava. So good morning, and as Slava said, let's take another few minutes for other participants.
As we started the introduction, Michał, thank you very much for co-hosting this webinar today. Michał is our people and organizations leader in Poland and in Central and Eastern Europe. And he will be joined today by 4 more of his colleagues, Michał Malkiewicz, Michał Balicki, Ivona Bonecka, and Bartosz Szywiak. So we wanted to talk today to you about the challenges that each of us experience in Poland and move from the personal challenges into the corporate challenges. And if I say it in a very simple language, the idea of the webinar today is for you to make sure that you know what you need to know. And if you are responsible in your organization for tax, legal, and people matters, that webinar will give you a chance to know what you need to know about issues of your people and how your organization can manage it. And if you are not responsible, our webinar will give you a good chance to go back to your boss and tell him or her what he or she needs to know. That's in brief about our event today. It's already 9:02. If you don't mind, let's start. Let me discuss a little bit of a logistics for the webinar today. You will be having a chance to ask your questions. If you scroll down your screen, you will see Q&A facility there, and you can ask your question. We will try to answer this if the question is straightforward right during the webinar. I will analyze all the questions and we will try to address the most common at the end of our presentation. And if the questions are complicated or if they're so specific, be sure we will come back to you very shortly after the webinar. I see more people are joining, and maybe we can start, Michał. What do you think?
Yeah, I think that this is a good time to commence. So let's start. Yep.
All right, maybe I will make a short introduction of what to expect during the webinar today. As I said, the idea is what you need to know and what your bosses need to know about the people issues in Poland for the time we are all forced to flee from Ukraine and stay in Poland and work from Poland. So we will be describing today the general rules and general issues. We all read the newspapers every day, and sometimes the journalists share with us positive interpretation of the rules. Sometimes the interpretations are not that positive, and I think it's good to listen to the experts who know the Polish law and most recent updates and interpretation and understand what the rules are. After that, we will go into 3 practical scenarios typical scenarios of Ukrainians being in Poland these days, and we will summarize at the end of the webinar the action plan for each of you. So I give a floor to my colleagues. Let's start.
Okay, so that's thanks again, Slava. Before I jump in once again, I invite you very warmly to ask questions in the chat, use that functionality that Slava mentioned. Anyway, we will keep time at the end of the presentation to answer them. But in the meantime, yes, please ask. Please treat this webinar as much interactive as possible. Just a few words of introduction, not going into the difficulty of the situation, geopolitical situation, the war situation itself, but of course to give you a flavor in which environment we are taking into account businesses that you are running or your organizations are running, and the question of employees or your co-workers. Of course, the formal moves between Ukraine and Poland, some of them changed, some of them were stopped. What I mean is a formal secondment or assignments, but the situation that you are facing led to the fact that so many of your employees work from abroad, they looking from the Ukrainian perspective. And of course, we are today to concentrate on the Polish obligations and the situations that are created for people in Poland. And this there could be different responsibilities which are covered by the several different types of the legislation, court verdicts, or the interpretation, as well as Slava said, this is something that the journalists, that the newspapers, or the other internet portal are commenting. Unfortunately, not always very correctly from the technical perspective. You know better than me that many of your people, or maybe majority of your people, work remotely, and there is another twist in this. There are some regulations in Poland regarding remote work. There are some, I would say, interpretation, OECD interpretation, how to treat it, but there is no one regulation that is covering this. So we will go through the specific scenarios most common in the situation that you are facing, and before that we will briefly remind you or present you the some of the main rules. But if I may underline and try to provide you the overarching principle of what we see is important, taking into account the issue of remunerating, employing people in a various formats, either as employees, working remotely, working maybe in the hybrid mode, or your co-workers working under the B2B arrangements. There would be, of course, tax, personal income tax matters. There will be the tax residency issues, which are crucial to assess first whether someone is a resident or not, because there are different implications in one on the other. Of course, labor law matters needs to be taken into account even before we see the tax, what would be the tax treatment, but we always look at in a parallel, so make sure that we can find the best option at the safe one. This may result in necessity of updating some regulations, policies in the firm. And last but not least, the way you are employing people, the model you choose or you have to choose will imply the different corporate tax issues. And it's indeed how we would like to present you the real cases or most common cases, to make sure that we are covering all of these five most important areas, and to give you the real practical advice how to act, what to do in the middle of the September when we are in this situation. You are in this situation for a half of the year, and our employees are in this with you. So that would be as a starting point, and giving some flavor of how the further presentations will go. And I will pass to Ivona now, who will remind, or for some of you, and present for some of you the main rules regarding few crucial topics to be on the same page for the further specific scenarios to be discussed. Ivona, over to you.
Yes, thank you. Good morning to everyone. Thank you, Michał. Thank you, Slava. So as Slava and Michał said, in our practice, we have full overview of type of companies and employees in these areas, but in many cases, the analysis on a case-by-case basis are required. And depending on the concluded employment contract, whether it is foreign employment contract, Polish employment contract, or other forms of employment, the entities and the person working in Poland have various obligations related to the settlement of income from work performed in the territory of Poland. And with regard to the Polish personal income tax, we always start from tax residency. And in order to assess the tax consequences for the individual, his/her tax status, residency status should be determined. And based on the Polish tax rules, individual may be considered as Polish tax resident in case he/she spends more than 183 days on the territory of Poland in a given tax year, and her center of vital interest, understood as center of personal and economic interest, is located in Poland. And we have two groups of individuals. Individuals who have a place of residence, so I will switch to the next slide. Individuals who have a place of residence in Poland are subject to Polish taxation on their worldwide income, irrespective of where the income is sourced. And on the other hand, persons who do not have a place of residence in Poland are taxed only on the income sourced in Poland. And it is very important that it is enough to meet one of the mentioned conditions for a person to be considered a Polish tax resident. And with regard to the residency, the most objective criterion in determining tax residence is the length of stay. And a significant part of Ukrainian citizens who came to Poland left the country immediately after the outbreak of the war, and therefore, in their case, exceeding 183 days in Poland may occur soon. It means at the end of August or still in September this year. And this may result in the fact that the first condition of tax residence will be met, and these individuals should be considered tax residents in Poland in accordance with Polish law. And in a situation where a person does not meet this condition, further analysis is necessary. And the next criterion should be analyzed: the center of personal interest. And here, first of all, family, social, political, and cultural ties should be taken into account. And considering that people from Ukraine left their homes during the evacuation, in their case, they stay in Poland may still be temporary. However, if some of them, for instance, singles with no close family ties to Ukraine, settled in Poland and intend to stay here longer, it may mean that on the basis of this criterion, they will be considered Polish tax resident. And economic In short, if a Ukrainian citizen, for instance, does not have the main source of income in Poland, he or she is unlikely to meet this criterion. But on the other hand, a person who could take up a work in Poland and this work will become the main source of his income could be considered a Polish tax resident. But what results from the double tax treaty? Because additionally, in the event of a conflict of tax residence, for instance, if a given person will be treated simultaneously as a Polish and Ukrainian tax resident on the basis of local rules, preference should be made to the provisions of the agreement of avoidance of double taxation concluded between Poland and Ukraine. And the criteria resulting from this agreement, permanent residence, closer personal and economic ties, habitual residence, nationality, will ultimately decide which country is the taxpayer's residence for tax purposes. Because you cannot be a tax resident in two countries at the same time. So it may be very helpful to obtain a tax residency certificate issued by Ukraine under a double tax treaty. So as you can see, determining tax residence, as Michał said, can be problematic, and moreover, it has significant consequences, especially for taxpayers who work in Poland on the basis of a foreign employment contract or have other forms of employment. So each time such an analysis requires an individual approach. And what are the guidelines of the Ministry of Finance? Due to the emerging doubts of the determination of the tax residence of Ukrainian citizens, the Ministry of Finance recently presented a letter of July concerning the guidelines for determining the tax residence during the war, Ukrainians during the war. And it seems that the Ministry of Finance confirmed that as a rule, determining tax residence should take into account both Polish regulations and international criteria, but the approach of the tax authorities may be in practice during the war more flexible and individual, depending on the situation of a given taxpayer. So this may mean that in the event of the conflict of residence on the basis of a double taxation avoidance agreement, Ukrainian citizens will be able to remain Ukrainian residents even after exceeding 183 days in Poland, if they retain their center of vital interest in Ukraine. And what about with avoidance of double taxation between Poland and Ukraine? In the event of taxation in a country other than the country of residence, one of the methods of avoiding double taxation should be applied. And the country-specific method is described in the said double tax treaties. In this context, in the double tax treaty concluded between Poland and Ukraine. And double tax treaties provide for two methods of avoiding double taxation: the method of exemption with progression and the method of proportional deduction, which is called tax credit method. From the Polish side, it is exemption with progression, but while discussing the first scenario, I will briefly tell you what they are with regard to specific Ukrainian cases of avoidance of double taxation. And a very important topic, social security, which is quite a difficult topic, because note that with regard to Ukraine, we refer to the bilateral agreement concluded between Poland and Ukraine on social security, which was introduced to avoid double accumulation of the same income. So if a person from Ukraine performs work in Poland, for instance, under a Ukrainian employment contract, as a rule, social security contributions are also payable according to the pay where you work principle, unless such a person would be delegated to work to Poland by a Ukrainian employer. Then you can apply the bilateral agreement between Poland and Ukraine on social security, which in principle allows you to pay contributions in Ukraine. However, it should be noted that in most cases, Ukrainian citizens working in Poland on the basis of Ukrainian employment contracts are not posted, but rather work remotely from the territory of Poland. Nevertheless, according to the current social security authorities' approach, it seems that on the basis of a mutual bilateral agreement, such person should not have problems with the issuance of very important certificate, which is called UA PL1 certificate by Ukrainian counterpart of Social Security, even retrospectively confirming paying contributions to income in Ukraine throughout the war. But what about the provisions of war when the employee may not be able to obtain a certificate? How to proceed in such situations? So it is really very important to do full overview of the individual circumstances. Generally, it is required to properly manage the social security matters. For instance, in case of the employees working in Poland under the Polish employment contract, it means with the Polish employer operates withholding monthly tax advances. So it will also deduct obligatory social security and health insurance contributions. And thanks to being subject to social and health insurance in Poland, the employee will also be able to use benefits, including healthcare on the territory of Poland. So, Michał, the floor is yours.
Thank you, Ivana. I hope that you can hear me well. Good morning, everybody. It is another Michał and still another one to come, so there will be a lot of Michałs today, but I assure you that not only Michałs are working at PwC, and there will be also other presenters. The general rules regardless the scenario we will be talking about later also covers the situation of the legal stay and legal grounds to work in Poland in the aspect of the immigration provisions. Yeah. So currently, as of 12 March 2022, those issues are governed by the Special Act, which is the Act on Assistance to Ukrainian Citizens in connection with the armed conflict in the territory of Ukraine. That basically sets the rules for 18 months as of the date of the act, so basically till August 2023. So every aspect of the legal stay in Poland and legal work or conducting business to that matter is governed by this act, and throughout the presentation you'll see that we'll be referring to that act a lot. So the said act basically provided a starting point, which is 24th of September 2022, as a day from which the person that entered Poland can say that legally stay in Poland. The act basically covers all the Ukrainian citizens that came to Poland after that day, together with their spouses. And the act provides for the exception that the spouses, if one of the spouses has got the Ukrainian citizenship, the other may not have that citizenship, but still can legally stay in Poland based on that act. Also, the Ukrainians having the Polish card, that they can come to Poland with their closest relatives, and they can legally stay in Poland for the 18 month period. The act is as of March 2022, but since then it was changed a couple of times. And one of the changes to that act also is that it covers the employees who were assigned to Poland and that are assigned out of Poland. So in the situation when the employee is working from the territory of Poland for the Ukrainian company, and that Ukrainian company decides, or Polish company also decides to assign the employee, let's say, to, I don't know, Germany, France, or whatsoever. And this act will also cover that person, and that person will not lose the privileges granted by this special act, like allowances and the legal stay in Poland. Another tricky part that needs to be remembered, that in order not to lose the privileges granted by the special act, Ukrainian citizen that is covered by the special act cannot leave Poland for longer than 1 month in one trip. You can say, yeah, because at the beginning there was a problem with how to calculate. How to interpret the provision on this 1 month rule, whether it was consecutive stay or during the 18th month, you cannot leave Poland for longer than 1 month. So now basically it's changed, and the interpretation, of course, it's changed, and this basically means that the 1 month is calculated consecutively. Another amendments is that the special act allows Ukrainian citizens who came to Poland after 24th of February 2022 to ask for temporary stay in Poland after 9 months of staying in Poland. So let's say that on the 25th of February, Ukrainian citizens came to Poland, and after 9 months, starting from that date, that person can submit the petition to be granted with the temporary stay. The temporary stay is for a period of 3 years, and I must say that the conditions under the special act are a little bit better than those provided by the act on foreigners. Yes, so it is something to consider to submit the documents for the temporary stay in Poland. Yeah. So the first day is 9 months since we came to Poland, but those documents cannot be submitted later than the 18th month of the legal act, the special act. So basically before the August 2023. In terms of the legal stay, apart the special act, I mean, so for those citizens, Ukrainian citizens who are not covered by the special act, there are also other types of means that can basically grant them legal stay in Poland, especially if the Ukrainian citizens already were in Poland after and before 24th of February. So the visas and temporary stay that will end near the 24th of February was automatically prolonged till 31st of December 2022. Other documents were prolonged for the period of 18 months, then again calculating from 24th of February 2002. So it's correlated to the special act that was put into the Polish legal system in March 2022. 2022. Basically, the same situation is when the last day of the allowed stay in Poland was after the 24th of February in terms of the Schengen visa or documents for other from other countries that allowed to stay in that country, and the non-visa movement. It was also prolonged for another 18 months. So this basically shows that there are many ways to grant legal stay in Poland, which is the basis basically for the legal work in Poland. Because the main rule provided by the Special Act is that if you, as a Ukrainian citizen, get a legal entry, so that basically means that you can legally stay in Poland, and this basically expands to the legal work in Poland, so that the Ukrainian citizens are entitled to work in territory of Poland when they are covered by the Special Act. And on the side of the employers, the only obligation in that situation basically is that to submit a notification to the Powiat Labor Office within 14 days from the date of commencement of the work. And this is basically done online. The form should be filled out online, so there is basically not much formalities in terms of the legal work of Ukrainians here in Poland. Yeah? This also covers, as we said, the background for the scenario that we will be discussing. This also covers the situation of starting and conducting business here in Poland. The only difference basically is that if the Ukrainian citizen would like to start a business either as a sole entrepreneur or establish a company, so the only rule, basically the additional rule, is that such person needs to have a PESEL number, so the Polish identification number. But from what I know, many Ukrainian citizens already has got that number, because that was something also necessary when the Ukrainian citizens wanted to make use out of the Special Act and the privileges that the Special Act was granting, especially in terms of the financial support and financial aid. So basically, in a nutshell, in terms of the immigration rules, those are the most important parts. So basically, we need to observe the 18-month period. We can ask for temporary stay in Poland for 3 years after 9 months since we have entered Poland. And when we employ Ukrainian citizens with the right to legal stay in Poland, we need to remember to submit the notification to the Powiat Labor Office within the 14 days. And everything basically relies on the date of the entry to Poland, which basically grants the legal entry equals legal state. So I would say that those 4 points are the most important points in terms of the immigration and legal stay, and then legal work in Poland. So right now I would like you to participate in a quick survey, the poll question that we prepared for you as our participants, that basically refers to the general rules in terms of the Polish tax, social security, and immigration aspects, and how you, as an employer, how do you support your employees with those issues? So I encourage you to provide an answer. I understand that the survey right now is visible, and if you could please choose one of the answers that will, show us how the situation right now is presenting, because as Michał said, there is a lot of different interpretation of the rules, and there is a lot of intermediary provisions that may confuse in terms of how we should act in terms of where to pay taxes, where to pay social security contributions in the situation where we're working from different places. I see that answers are piling up, and maybe I'll ask Michał and Slava to comment on the answers to the survey.
So thank you very much. I'm seeing the results of the survey. Not everyone voted yet, but it seems like not that many of the presenters in the organization have a full knowledge. Yes, people are getting advice from consultants and provide support to their employees. That will count around 50%, but still about 50% need further help to either further provide guidance to their employees, or just basically say, okay, you have to find out yourself. What we can offer in this case is, if you are in this position, let's do it together. We can help you like we're doing today. We can help you sit down with your people in your organization and have this conversation very, very openly. So thank you very much to those who answered the poll, and let's move on.
Okay, thank you very much, Slava. Now we would like to concentrate on practical scenarios and concentrate on the scenario when Ukrainian employees work remotely from Poland for a Ukrainian employer on the basis of a Ukrainian contract. What are the duties? How the income from work is taxed in such a structural arrangements? Currently, there are no legislative changes introduced on a local or international basis in the field of taxation rules for Ukrainian citizens working in Poland, employed on the basis of Ukrainian employment contracts. Therefore, the provisions in force regulating the principles of taxation of such income should continue to apply. So according to these regulations, regardless of whether a given person is a Polish tax resident or not, if he or she undertakes gainful employment in Poland, as a rule, he should tax the income obtained in the country of work. It means in Poland. And the situation related to the taxation of Ukrainian citizens who moved from Ukraine to Poland, some for short time, others for longer, others with the intention to settle in Poland permanently, may become significantly complicated if a given person is continue working for the Ukrainian employer performing his/her duties remotely from the territory of Poland. Because as a rule, the formal employer will still be the Ukrainian entity. So in such a scenario, the employee will be personally responsible for paying monthly tax advances to the Polish tax office, because the place where a given person performs work is of fundamental importance for tax purposes. So if such income is taxed in Poland, it will be necessary to calculate the tax advance in accordance with Polish tax regulations and pay it to the Polish tax office by the 20th day of the month following on the month in which the income was received. In this case, there is also an obligation to submit an annual tax return. There is, of course, the exemption provided in the double tax treaty to this rule, which allows non-payment of tax in Poland, because pursuant to the provisions of the double tax treaty concluded between Poland and Ukraine, a person in Poland on the basis of a Ukrainian employment contract may be exempt from taxation in Poland if the following conditions are met. The person has the status of Ukrainian tax residence. A person will spend less than 183 days in a given year in Poland. Remuneration is not paid to the person on behalf of the Polish company or recharged to a company in Poland. Remuneration costs are not borne by the establishment or permanent establishment that the Ukrainian employer has in Poland. So if at least one of those mentioned conditions will not be met, it means, for instance, the Ukrainian resident who will exceed 183 days in the territory of Poland in this calendar year, the tax will, however, be due in Poland. And therefore, if the stay of a Ukrainian resident in Poland exceeds 183 days this year, for instance, in August, he will have to tax in Poland the income obtained for work physically performed here, obtained on the basis of a Ukrainian employment contract, retroactively from the first day of work in Poland. So the first income tax advance for residents of Ukraine may therefore be due in August on income for the period February-August 2022 and will be payable until the 20th of September directly to the individual tax micro account. In addition, the taxpayer, a citizen of Ukraine, will be required to submit his tax return for 2022 to the competent tax office, and the deadline for its submission is the 30th of April of the following year. Natural persons earning income from work in Poland, as a rule, are taxed on the basis of a progressive tax scale, 12% up to the 120,000 and 32% above this threshold. And I promised to come back to avoiding double taxation case, because the tax recovery can be, with respect to the Ukrainian citizens, may be quite difficult. Because in the event that, according to international regulations, a given person will remain a Ukrainian tax resident in a given year, but will be taxed in Poland at the same time. It means, for instance, in connection with the breach of the set mentioned condition of tax protection, it means exceeding 183 days in Poland, it will be possibly to apply an appropriate method of avoidance double taxation. And according to the double tax treaty between Poland and Ukraine, as a rule, a Ukrainian resident should be able to apply the method of proportional deduction tax credit, the essence of which is that the tax paid in Poland should be deducted in an appropriate proportion from the Ukrainian tax, calculated on the total income. So in practice, with the current approach of the Ukrainian authorities, in the case of the employment under a Ukrainian employment contract and withholding tax by a Ukrainian employer, crediting the Polish tax, it means recovering by the Ukrainian tax resident at least part of the tax paid in Ukraine, may be difficult or even impossible. Also, in case of a Polish tax resident, there may be a risk of a double taxation of income obtained under the Ukrainian employment contract due to the the inability to recover the Ukrainian tax paid by the employer in Ukraine as part of the local payroll. So, as we said, the role of the employer is to ensure that the employees are familiar with these aspects, tax regulations, which are not always clear and not straightforward. Thank you. Michał, the floor is yours.
Okay, thank you, Ivana. Third Michał during today's presentation. Good morning, very glad to meet you all during this presentation. So we've heard quite a lot about the personal income tax aspects of taxation of Ukrainian employees being physically in Poland. But what is also important is to remember that the presence of staff of Ukrainian company in Poland may also trigger certain corporate income tax consequences for the Ukrainian taxpayer. Basically, we are talking here about the permanent establishment concept, whereby the presence of personnel in Poland may create so-called taxable presence of a non-residents in Poland. It's not very intuitive in a way that normally we think that I need to have a company, I need to have some legal presence in Poland, for example, a branch or a subsidiary to be subject to tax. And that's not really the case. Very often, only the presence of personnel that has certain length of stay may create taxable consequences and obligations for a Ukrainian employer to register for corporate income taxes in Poland. I'll tell you more about this during this slide. So basically, there are three possible concepts of PE creation, so permanent establishment creation. It's a fixed establishment, dependent agent PE, and construction PE. The most common case is the fixed establishment. It's basically a situation whereby the Ukrainian taxpayer, through having its employees, contractors, people who are dependent upon the Ukrainian taxpayer, are in Poland and are using certain amount of space that is at the disposal of a foreign Ukrainian taxpayer. And through this fixed place, certain business of a Ukrainian company is conducted in Poland. This place needs to be at disposal, so not necessarily the company from Ukraine needs to have a legal title to the establishment. It can be rented, it can be simply used by that entity. And if through such fixed establishment we permanently conduct business activities in Poland, and when I say permanently, we mean basically half a year of continuous activities, that may create a so-called PE, so permanent establishment for the Ukrainian company in Poland. So simply the taxable presence, there is a nexus created with Poland, and as a result, there needs to be a certain amount of tax of income allocated to the PE and subject to the corporate income taxation. The second concept is a dependent agent PE. So it's a situation whereby we don't even need to have a permanent stay, a fixed place of business, but it's enough if we have some personnel being involved in sales activities, interactions with client, and who are dependent on us. And when I say on us, on the Ukrainian taxpayer, and they conduct certain sales generating activities, like, for example, are conducting agreements with the Polish customers on behalf of the Ukrainian company. This can create a dependent agent PE issue. And this is irrespective of the length, of the duration of these activities. So it's important to know that if you have certain personnel that is engaged in the sales activities, this may also create a PE in Poland. There are certain exemptions from the PE, as you may know. If the activities of your personnel in Poland is more of a preparatory of auxiliary character, so they do not constitute a part of core activities or constitute such activities as, for example, warehousing activities or collecting information for the Ukrainian company, etc. When these activities are conducted even through the fixed establishment, there is a chance that no PE will be created. So we'd like to reiterate that this PE assessment is very subjective. The Polish tax authorities tend to be quite aggressive in terms of the PE existence in order to tax the foreign non-resident. So just as a takeaway, it's important for you to simply monitor the length of stay. This half a year should be some sort of a threshold. Or if we have this dependent agents in Poland, we don't even look at the period. It's enough if they are there and they are conducting the activities. Monitor the activities to say whether or not we fall under this PE threshold. And if yes, the consequences are simply that we need to register the Ukrainian taxpayer in Poland for CIT to get any NIP number, so tax identification number. We need to allocate the income to the PE in accordance with the arm's length terms, so at arm's length level. And in general, the corporate income tax rate in Poland is 19%, and this income would be subject to tax proportionally to the activities conducted in Poland. And if we fail to do that, of course, the consequences are potentially tax liability, late payment interest, and also fiscal penal sanctions for individuals, for the management of the non-resident. So it's just important to remember that not only we need to take care of the employees and their obligations from PIT perspective, but also potentially CIT presence can be created in Poland if these activities are conducted. We'll have a question on the PE in the next survey pool. But now I'm passing voice to my colleague to discuss legal and immigration implications. So thank you for this part.
Okay, we can actually cover that element in previous section, so we can directly go to the polling question. I see that there are also questions related to PE, but let us first ask you the question which is relevant to that topic, and while commenting your answer to our question, we will maybe address quickly, at least now, the questions about PE you have. So let's go to the survey.
Okay, so the question is simply, do you believe that the physical presence of your employees in Poland may create a PE in Poland? So the possible answers are yes, and you have already registered for CIT. Second answer is that it may, but due to this temporary character of stay, you think that no PE should be existing. And the third option is that potentially you may have a PE, but you are not sure, and you believe that the additional analysis is needed in this respect. And the fourth option is that you are confident that no PE should be created in Poland due to these activities.
Okay, yeah, and we thank you for answering the questions. That's the majority of your participants believe that the situation in which you are in Poland does not create the PE risk, but it's around half of you. But anyway. Some of you believe that the PE may appear here, and also, Michał, you have partially covered this based on the regulation, but also the prevailing interpretation of the Ministry of Finance. But there were questions really on specifically whether 183 days. Has an influence on recognizing a permanent establishment in Poland, and then there is also a question of some other features or the situations or elements that may increase the risk of PE. And if we may at that moment, maybe trying to give the highlights or some spot or some ideas how to approach this to the audience.
Yes, so basically, thank you, Michał. Basically, the 183 days, that's the threshold. It does not result from the law, from tax regulations, but more from OECD commentary. And that's the practice of the Polish tax authorities when they assess the PE risk from the fixed place of business perspective, this first concept that I was describing. And again, this dependent agent PE, it's remember to know that then the length of activities is not necessary. So it may be even a month of activities that then create a permanent establishment. So as I said, it's very subjective. From the responses, we can see that answer C, potentially you may have a PE and you need an analysis. That's probably the good situation to ask for advice. Also, potential option is going for a tax interpretation if the situation is ambiguous, is not sure, to the tax authorities to ask for their confirmation. There is also such an option to have like a certainty in terms of how to react and whether or not we have a PE or not. But as Michał said, the majority of you, 47%, believes that no PE in Poland is created. And also not created due to temporary character of stay in Poland. That's absolutely true. Still, as Iwona mentioned, half a year threshold is about to finish. So you need to monitor to check if by any chance we do not exceed the period. And if we conduct a part of core activities in Poland, that potentially PE may be created.
Thank you, Michał, and thank you all for participating in this question. We need to speed up a little bit, and of course, if needed, we will come back at the end to permanent establishment topics. Now we are coming back to our presentation and going into the scenario number 2. Yes, so I'm passing to my colleagues.
Yeah, and it will be me. I will break the pattern, but by not being named Michał, I'm Bartek. We'll discuss now scenario 2. Basically, the scenario 1, which was described by Iwona, is probably the most straightforward from the perspective of, let's say, factual circumstances, because you basically need to have a Ukrainian employment contract and start work on the territory of Poland, and no legal actions are required. Basically, the consequences are there somewhere in the background and needs to be analyzed. But probably you will agree with me that in this first scenario, it's not straightforward from practical perspective, because there's a lot of things to be analyzed, verified, conditions, and the compliance itself is a bit complicated because the individuals, the employees, have significant share of obligations on them. So we will discuss now the alternative situation, which happens often in our practice, where the Ukrainian employers establish their legal presence in Poland, and they conclude with the employees' Polish employment contracts. This situation may be beneficial from many perspectives. Basically, it gives 2 benefits I will focus on, because the first one is a bit of simplicity. Because if we are talking about the person, the employee who is working on a Polish employment contract, this situation in 100% cases leads to an obligation to pay Polish personal income tax related to this income derived under such a contract. So you don't have to analyze whether you exceeded 183 days, whether you have PE in Poland, or if anything is paid by a Polish entity, because it is paid by a Polish entity. So you, on one hand, you obviously need to pay tax in Poland, but you don't have a burden of further analysis of tax consequence. Obviously, the tax residency has some meaning, but it has a meaning only in the area of whether you need to tax only Polish sourced income or your worldwide income in Poland. But your employment income would be obviously taxed here. From the economical perspective, so the tax rates and the tax cost, it's basically pretty similar to what was described in the scenario 1, because the employment income derived under Polish employment contract is taxed as well at 12 and 32% scale, with the threshold at 120 zlotys per year. What makes a significant difference compared to the scenario 1 is that if you have the Polish employment contract, it is the company, the employer, which does majority of the admin behind the taxes and social security. Because in case of Polish employment contract, it's not the employee who is obliged to calculate and pay the tax advances, but it's the sole obligation of the employer. The employer needs to, on a monthly basis, calculate and pay taxes, analyze whether certain elements of pay are taxable or not. And at the end of the year, the employer is obliged to submit declarations to the tax office. One PAT4R is related to the tax advances withheld throughout the year, but most important for the employees is the PAT11 annual income statement, because this is basically a declaration, the information of annual income, taxes, and social security withheld by the employer. Based on this document, you are able to prepare and submit your annual tax return. So as you may see at the very first look, the situation is, from practical perspective, much more straightforward, because you don't need to calculate the taxes on a monthly basis. You get the information what should be reported from your employer. Obviously, as I mentioned, at the end of the year, there's necessity to submit the annual tax return. But it's the case for everybody who receives any income that should be taxable in Poland. Obviously, there may arise a question: what happens if I'm a Polish employee, but I will be working partially from the home office in the Ukraine? Basically, the situation would depend, obviously, on your residency status. Because if you are the Ukrainian resident working on a Polish contract, but for some time, visiting a family in the Ukraine and working from home office, based on double tax treaty rules, your days of work spent in the Ukraine would be taxable in Ukraine. But at the end of the day, it is the employer obligation to reflect this situation in your PAT11. So at the end of the year, you will receive the information what share of your annual income should be taxed in Poland, and what part should be allocated to Ukraine. Similarly, if you are a Polish tax resident, you need to go through the double tax treaty exemption test described by Ivona, and verify whether your presence in the Ukraine would be taxable in Ukraine. But again, final allocation of your income should be reflected in the PAT11 by your employer. And based on this document, you will submit your annual tax return. Additional advantage, very practical advantage related to this PAT11 form, is that the Polish authorities offer significant ease of filing the tax return based on PAT11, because it is possible for you to make an e-filing. And if you have only employment income received under PAT11 form and no further income sources to disclose, basically it may happen almost automatically because the system works like based on the PAT11 itself. The tax return is pre-filed by the tax authorities, so it gives you a possibility to focus on your daily work rather than your potentially complicated tax situation. And as I mentioned in between the sentences, the Social Security is also payable in case of Polish employment contract. But again, it's the Polish company or Polish branch of the Ukrainian company which is obliged to calculate and pay the Social Security, and the company does all the reporting behind that. On the topic of how to become a Polish employer, I will give a mic for a minute for my colleague Michał Balicki.
Yes, thank you, Bartosz. It's me again. So basically, in that scenario, Bartosz talked a lot about the employer, and from that perspective, you can ask the question how to become an employer. So first, what is important from the Polish labor law perspective, an employer is an organizational unit, even that has no legal personality, but employs employees. So in terms of the legal personality, we mean here the basically two types of companies, you can say. One is the type regulated by a Polish Code of Commercial Companies, which is the limited liability stock company and so on. And the other type is, for example, if a Ukrainian company would like to open a branch here in Poland, or if a Ukrainian citizen would like to become a sole entrepreneur under the Polish law and start employing employees, basically. So this would allow that entity or natural person become an employer, who then, of course, to as a last step, would need to sign an employment contract with the particular person. So, in a nutshell, those are the steps that are required for a company or a natural person to become employer. And then all the issues that Bartosz said about will apply to such an entity. And Bartosz, back to you.
Yes, we will now go through the third poll question. This is basically related to the last slide. We would like to ask you, have you moved your business or opened your legal presence in Poland due to war or wider geopolitical situation? We have a few options to select. Yes, I have set up a new entity in Poland. So this would be correct if you opened a new Polish entity like spółka z.o.o. or spółka akcyjna or any similar legal form. Yes, I have set up a branch in Poland. So if you have a Ukrainian company with the formal branch registered in Poland, no, but my employees are working remotely from Poland. So basically, this is the situation that is covered by this scenario one. And no, my business, including employees, is still in Ukraine. So this is an option for the situations where you considering moving your business in Poland. And I'll ask Michał and Slava to comment on the results.
Thank you, Bartosz. Yeah, let's maybe still give time for the participants to answer, but yeah, we see that there are a few cases when you set up the company or you had to, or you wanted to establish a branch of your headquarter company located in Ukraine. Yeah, but at the same time, there are also like almost 40% of you who answered the question that you are working. I mean, your employees are working, or you are working remotely from Poland for the benefit of your Ukrainian company. So we have a variety of the answers, I would say. And also we have participants who answered that business, including employees, stayed in the Ukraine. Yeah. So as you have heard, comparing to the scenario one, there are the 183 magic days is not appearing here, but there are other consequences of such a setup of employing people, and the results of the survey shows that that option is also used by yourself as employers. And now probably we are not receiving many more questions. So variety of the situations, I would say partially new entities, partially working through the remote workers from Poland. We are now switching to a little bit and coming to the self-entrepreneurial or business to business B2B arrangements. And I will ask Bartek to cover this, especially that there are a few questions, and thanks for the questions you have asked in the question and answer panel. So Bartosz, once again, over to you for the B2B arrangement and tax consequences of this.
Yeah, so as Michał mentioned, scenario 3 covers this self-employed question, or I will use B2B to make it simple. Basically, this situation may happen in practice in two cases. I think so. The first one is when you had the business activity set up in Poland, set up in Ukraine, and you moved to Poland, and the question arises: where should you tax your business activity? But nonetheless, it's also looking from only Polish perspective. It's also quite common engagement structure, especially in certain areas, like certain industries, like an IT industry, for example, where the B2B contract is say significant alternative for the employment relationship. So what does the double tax treaty between Poland and the Ukraine say about the self-employed income? Basically, if we are talking about B2B activity, the income as per double tax treaty should be taxed in a country where this activity is registered. However, it may be taxed. So let's say it's the Ukraine. However, it may be taxed in the other country, here in Poland, if this business activity is carried out in the form of the permanent establishment. So we are referring here to Michał Malkiewicz's comments on the PE creation, because it may be possible that the PE is created not only for the, let's say, legal entity like the company, but for the natural person who is running business activity as well. And here the fixed place of business concept would play a huge role, because as you can see, we have basically three or four, depending how we break it, conditions. So we will need to analyze whether this entrepreneur has a place in Poland where the activities are carried out, whether it's permanent, and what type of activities is carried out. To to make a long story short, probably if you're thinking about your personal business activity where you're programming, for example, it would probably be hard to argue that this is an auxiliary or preparatory service, because basically if we are working on the B2B contract and we are doing it from the home office arrangement, we are basically doing our core business. So this means in practice that if you have the business activity and you are working physically from Poland, there is a significant risk that the PE on this personal business activity is created in Poland. So this would, in practice, mean that your business activity may become taxable in Poland. How do we tax the business activity income in Poland? Basically, Polish tax rules allow you to choose your tax regime. There have been significant changes to this this year. Well, then basically, as a default, the business activity is taxed similarly to the employment income. So we are talking about the tax scale of 12 and 32%. But obviously, more common solutions are more beneficial tax regimes like flat rate taxation, where your business activity income is taxed at flat 19%, or a lump sum taxation, where your B2B income is taxed, B2B revenue, in fact, because you don't deduct the cost in this tax regime, is taxed on the rate applicable to the type of service that you provide. And the tax rate here may differ from 2% to 17%. And if we are talking about the IT industry, this particular industry has a quite common, quite widespread, even more beneficial regime of called IP box relief, which allows you to tax your income from, let's say, sale of your intellectual property rights created by you at only 5%. Obviously, next to taxation, there is the social security, and here we need to focus on two things. First is that the social security regime on self-employed income is basically more beneficial from the cost perspective than on the employment income, because the social security contributions are not paid on the actual income received, but at the minimal standard basis of 60% of the projected average monthly national salary. Next to social security, you have the health insurance contributions, and the health insurance regime depends on what type of tax regime do you apply. Basically, it varies from 9% paid on the income, total income less social security for the tax scale, to the lump sums paid in case of a lump sum taxation. What is important from the perspective of Ukrainian business activity performed physically in Poland, theoretically, it is possible, as per Polish and Ukrainian bilateral agreement on social security coordination, to obtain UAPL1 certificate for your B2B activity. So similarly to scenario one, for a person conducting business activity, it is possible, while having this certificate obtained, to still be subject to Ukrainian social security. What is maybe not very straightforward, it is possible, therefore, to be subject to social security in the Ukraine because you have the certificate, and be taxable in Poland. So those two regimes may be subject to different country rules. And now we'll move to last poll question. This is a kind of look in the future.
Before we go into this question, if we come back, as there are some questions related to the business activity itself from the audience. So if we can, I hope that you can cover this. One of the question was that whether the minimal social security contribution paid in Ukraine by the self-employed person allows not to pay the Polish social security contributions either as an employee or a B2B contractor.
Yeah, so my answer here would repeat the UAPL1 certificate, because if you have either as an employee or as a self-employed person obtained the UAPL1 certificate, so you're either employee posted to work in Poland or you're self-employed person who is temporarily conducting the business activity from the territory of Poland, and you have obtained this certificate, the social security contributions paid in the Ukraine would be sufficient. However, we need to bear in mind that this certificate has a temporary nature, so it would work only for as long as 24 months. And if your stay in Poland would exceed that period of time, then basically you would be obliged to pay Polish social security.
Okay, thank you, Bartek. Yeah, I understand that we have started the survey on the last questions, the last poll question. So we can come back to this, and then let's analyze this for a moment. But for sure, we will cover the questions you have asked during the entire event. And then we will cover this in a moment. But for now, we just wanted to ask you that what are the other interesting topics for you. We are glad to meet you again at some moment. The situation is agile, so the option of still being in Poland or running business in Poland or having your employees in Poland is probably one of these that needs to be still reconsidered. That's why we have asked 3 questions on what would you like to hear again when we organize the next webcast, WebEx. We answer whether you would like to hear more details about the corporate taxation, or whether you would like to hear about the tax incentives for both companies and employees in Poland, and maybe going a little behind of the taxes and legal, whether you would like to hear and see the tools that are interesting, the modern tools of motivating employees, especially during these times of working remotely in a hybrid mode. And it seems that money is the king. So you would like to hear about tax incentives. We will of course take this into consideration. Yes, this is a topic. There are quite a few incentives on both the companies, either the corporations, so limited liability companies or joint stock companies or other, as well as the entrepreneurs being the employers, and for entrepreneurs itself, as well as there are different incentives for employees. So we are taking this into account. Thank you very much for answering this question. For sure, we will be preparing another event, and this is of course also to Slava. But as we see, information, advice on how to use and what incentives are available for the companies and for employees, this is something that you would like to hear. Any comments, Slava, on your side at that point? Or should we move quickly to answer to the questions?
Yeah, let's probably move to the answer to the questions, because if I look at the questions, and if I can summarize them, we covered many of the things today. Just to be absolutely clear, one question, I was waiting for it. The question said, do we have any special rule issued by Ministry of Finance of Poland that would say that Ukrainian employees, Ukrainian refugees staying in Poland for more than 183 days are not taxable in Poland? And then I can start the answer, Michal, because we live in this environment of journalists talking about this every day, and they refer to the same letter issued by the authorities of Poland back in July. And if you remember, colleagues, that's sort of a difference from the Ukrainian rules. That's why it may be not that easy to understand. But when Ivona started the presentation, she said, Polish rules are, if you are a Polish tax resident, then you tax your worldwide income in Poland. If you are not a Polish tax resident, that the only thing you tax in Poland is your so-called Polish source income which is sourced from the territory of Poland. And then the Polish rules are that if I physically do the work on the territory of Poland, that income is sourced from Poland. And when we look at this letter issued by the Ministry of Finance, and I will ask Michal and colleagues comment now, this letter covers only the first part of the story. This letter talks about tax residency, the taxation of worldwide income. It doesn't say a word about Polish sourced income. So now I think whoever wrote this letter to the Minister of Finance, they simply asked a wrong question. And they've got the answer to the wrong question. So as I see it now, there is no favorable interpretation or a ruling from a Polish tax ministry. It may come or may not come. We don't know. I know that Ukrainian officials will bring in this matter to the Minister of Finance of all the countries in the world, but we have what we have for the time being. Michal, what is your view as leader of the Polish people organization tax practice? Do you interpret this differently?
Slava, I mean, we can say to the audience that, I mean, we both are talking about this every week, actually, taking into account the entire situation, the situation of you as a client, our clients, joint clients, or your clients. So I fully agree what you said. And then maybe to give you from the perspective of how we present it today, the most important is, as Slava said, not the residency, but the source of income. And this is the scenario one we presented. So even if someone still can be treated as a Ukrainian tax resident, but is in the scenario one, so working in Poland, from Poland, for the either Ukrainian entity or the Polish entity, or the Ukrainian entity, then and still being Ukrainian tax resident, when the 183 days pass, Poland has right to tax that income. And unfortunately, Minister of Finance never said anything about that case. I would what Minister of Finance said and did, in fact, was telling about scenario two more. So and also towards the situation when someone could be more easily Polish tax resident just by the virtue of declaring this to the Polish employer. yeah, this is another new, there is element of legislation introduced that if Ukrainian employee individual would like to be a Polish tax resident and is employed by the Polish employer, may declare that and become a Polish tax resident. Unless the situation, in contrary to the situation that we are discussing, so if you are working remotely for the Ukrainian entity, there are, at least for now, no signals that this means that the income will not be taxed in Poland. We are looking at this. We have some, our insights or at least contacts in the Ministry of Finance. But as for today, something what journalists said a week or 2 weeks ago that Poland seized the taxation of Ukrainian individual has no legal or even the interpretual grounds as for now. That's the situation.
Thank you, Michal. Thank you for this, colleagues. There are only 2 countries in the world now that clearly said no taxation this year. These are Ireland and Lithuania. For Poland and for any other countries, this may come. And the issue that we are all having right now is that 183 days are either past or approaching. As Ivona said, the Polish government would expect the advanced tax payments to start the next month after reaching 183 days. And if these advanced payments do not come, then a late payment interest is your exposure. So if someone does not make advance payments now, and the situation is not resolved by the time of the tax return filing deadline, so there is a late payment interest exposure. If the situation is resolved, there would be another question how to get this prepayment back. But that's really up to each of us to decide which way we want to go. As the law says now, we have to make advance payments.
Yeah. What I can say that, to add to Slava, what you said, this interest right now, taking into account the inflation and etc. in Poland are quite high, the 16% per annum. So take this into account. If you are deciding, when to pay or if to pay. But what I can expect that even if someone pay, which is the law, and if this 183 days is exceeded, there needs to be paid the tax advances by the 20th of the next month. If after that, Minister of Finance will issue any of the decree or whatever to seize the taxation, I'm sure, I'm very positive that if that happens, there will be also the procedure of claiming back if someone paid that tax advances before issuing such a decree. So, in other words, to be on safe side and act according to the rules, if there is this 183 days has been exceeded, tax advances have to be paid, and very, very likely, if at some point Polish Minister of Finance will follow the Irish or the Lithuanian one, I'm very positive that there will be also procedure to claim back the paid taxes if someone act accordingly and behave as a good citizen, good taxpayer.
Thank you very much, Michal.
Yep, you're welcome. We're probably both looking at the clock, and we are. We passed a few minutes behind the schedule. I think that we have covered the most of the questions that popped up during the meeting. There were questions about this 183 days and the residency. We talk about the taxation of the employment income after 183 days. Bartek answered the questions about the entrepreneur B2B relationship. Michał Minkiewicz covered the questions about permanent establishment. So I'm positive that the majority of the questions have been answered. If there are any others, you see the contact details of all of the team that had this privilege to talk to you today, and probably we'll be wrapping up. So over to you, Slava. As we all seen, hopefully we'll have the next webcast. There is an interest of the talking about the incentives, but in the meantime, please reach out to any of the individuals you see on the slide, and we will be happy to advise you. Slava.
Michal, thank you very much. Thank you very much to all the colleagues from Poland who helped us today, the three Michals, the Bartosz and Ivona. And my take from the discussion we are having today is that regretfully the situation with personal tax in Poland has not been clarified to date. And as I know, each of us is having a time pressure, and that's important to know that as of today, the situation is not clarified. That's my first takeaway. My second takeaway, perhaps those who ask questions about private entrepreneurs or individual entrepreneurs, B2B arrangements, we may have another round of discussions with you, because as you've seen from the presentation today, Polish rules for individual entrepreneurs are a bit different to the Ukrainian rules we used to have, and therefore there is a specific there. So we may need to go deeper into that area if you wish to. But as I said from the very beginning, you probably now have a good understanding of your challenges. But when you talk to your bosses and your organization, please pass this message to them that they need to think about the corporate challenges as well. And these challenges can have different angles, whether they need to have employee communication so that each and every person who is in Poland, in your organization, knows what the issues are. Whether an organization needs to provide an administrative support to employees, including you, if you are the employee, like, how to file a tax return, how to claim Ukrainian tax, how to go and get this social security certificate, not to pay social security taxes in Poland, and etc., etc. Then the organization may need to give you a financial support. I would assume some of the employees, for them it will be really difficult to make a tax payment for the past half a year in Poland, and then may come back to the organization and asking for help. There could be a publicity matter there. What if some of us don't pay tax in Poland that becomes public, how it will affect the organizations? And at the end of the day, the corporate tax matters. Yes, we always talk about permanent establishment. As we see today, permanent establishment is one way of legalization in Poland. Yeah, there could be a setup of business, there could be a branch, and I've seen your answers that some of you already started Polish business. The others may think go in the same way. And if the issues become significant, it may be worth for your organizations to put a strategy around that, to put a policy around that, and make sure you have a good corporate governance over resolution of all these issues. And Michal and I and our teams are more than happy to sit down with you individually and talk about how we can help your particular organization in these difficult circumstances. So thank you very much, and I look forward to meeting you again at our next event. We'll probably devote that to corporate issues, yes, as you voted for, but we'll definitely have a slot of time there to update you on the personal issues that were raised today. Thank you.